Good morning. Thanks for joining us today for those of you who are participating on the webinar and those of you here in our offices. My name is Heather Fields. I'm a shareholder with our healthcare department, and I chair our hospital and health system practice. Corporate compliance is one of the main areas of my practice that I focus on, and it's something that increasingly I am seeing corporations across many different industries are increasingly focused on and need to be concerned about in this enforcement environment, and also given the proliferation of regulations. Sorry about that, I couldn't get that word out. So what we're going to talk about today, obviously the attorney-client privilege, but I'm just going to try to make it very practical for you and help you understand how you can make sure that you're taking advantage of this very important protection for your client. It's particularly critical in corporate compliance because, very simply put, it allows companies to obtain the very best legal advice, and it also enables employees of corporations to have the types of candid conversations that they need to when they detect a potential or actual violation of law. So this is a really critical privilege to understand, and I think that after we finish today, you'll agree that it's worthwhile to take some time and plan for the protection of the advice that you give to your clients at your company, as well as any work product that you create, either yourself or by using non-attorneys. So with that in mind, we're going to start out by identifying the various types of privileges, and we're going to talk about the attorney-client privilege that protects confidential communications as well as the work product privilege. I'm going to highlight for you some recent cases and how they've affected the application of the attorney-client privilege. We've really seen an erosion of this really important protection as prosecutors and litigants increasingly try to get access to information and documents created by in-house counsel. I think that it's particularly important to understand this in the context of really the evolving role of general counsel in companies today. It used to be that general counsel had a very defined and segregated role in companies years ago, but in the last 10 years we've seen lawyers really becoming active participants in the business decisions of companies, and that has created some complexity in terms of ensuring the protection of confidential communications between employees and general counsel, in-house as well as outside counsel. Finally, we're going to discuss some very practical strategies that you can employ to preserve the privilege in your day-to-day advice to your clients. So let's do the basics of attorney-client privilege. I just want to make sure everyone is on a level playing field here before we get into some more advanced concepts. Obviously, the attorney-client privilege is an evidence concept, and whether you've established a proper basis upon which you can assert the protection it offers is always determined in hindsight. So that's really important to remember, that preparation and planning is going to be critical to your ability to preserve the privilege that you try to assert sometime in the future. I've highlighted for you the Wisconsin statute for your reference, as well the model rules. This doctrine has been around for hundreds of years, and it's a really essential basis of legal principles that a client and the attorney have a right to candid disclosures and communications for the purposes of obtaining legal advice. And that's something to keep in mind. That's really the crux of attaching the privilege to something, is that it really is for the purpose of legal advice. And that's going to be more relevant in today's world, where in-house counsel is often asked to participate in important business strategizing as well as business decision making. Obviously, there are exceptions for crimes or fraud, for a breach of duty by the lawyer or the client. or in the cases of joint clients. And we're not going to discuss joint defense agreements today, but some of the really significant cases that have come up in this area have been focused around joint defense agreements and whether they were appropriate. So the real key elements are that you have a confidential communication between an attorney and a client. And here's really where the rub occurs for those of us who work in companies, is who is the client? And I think that the ethics rules are absolutely clear on this, that the client is the corporation. And that's really important to understand, particularly as you educate your executive team and business managers. They understand that your legal duties inure to the benefit of the corporation. You don't represent any single employee. Obviously, everyone is working together for a common purpose and goal, but at the end of the day, it's really important when you want the privilege to apply that the folks with whom you are communicating understand that the client is the corporation and that they're very clear on that point. We're going to talk a little bit more about how you do that appropriately to ensure that the privilege will continue to apply. The communication has to be to a proper audience. So this is something that is really complex in today's world of electronic communications and emails because it's so simple to copy everyone or to send a particular communication to multiple individuals. And so it really requires you as counsel to stop and think about whether or not it's necessary to be copying everyone that you're copying, the desire to keep everyone in the loop, I think, and to really promote transparent communications among executives and members of the employees, other members of the management team, while I think is extremely important, needs to be balanced when you're trying to provide important legal advice to your client. So you really need to be thinking about your audience, and obviously it's also essential that that communication be kept confidential. I have had the pleasure of working in-house for 2 health system clients. One client for a period of about 18 months and another client for about 4 months. And I was working embedded as part of the legal team. And I can tell you it is very challenging when you're dealing with your business clients in terms of keeping your advice confidential. I can't tell you how many times my comments that were sent in an email to a contract or other document were then forwarded out to a wide number of persons, not all of whom were within the company. And I've had letters that I've written for clients that were then forwarded to the other side. And I think that what I'd like to leave you with today is a newfound goal of training and educating your executives and your management team as to the best use of the advice you give them and the documents you prepare for them so that they don't unknowingly or unintentionally waive a privilege that otherwise may come to be very important in the future. The purpose of the communication has to be to obtain or provide legal advice to the client. And this is the place where we see the dual role of the lawyer as business advisor and attorney really muddying the waters of privilege, because where you have a dual purpose communication, let's say, for example, you're sending an email with comments on a new marketing communication that's going to be sent out to your customers, and you have a number of comments you're providing in the text of that, some of which are just your good business advice, knowing your company and your market, and some of which are for purposes of complying with applicable regulatory requirements. You've got a dual purpose communication, so it's extremely important, if you intend that to be privileged, that the primary purpose of that be for legal advice, and you try to separate out where you're acting as a participant in the business decisions versus when you're providing legal advice. Only the communication is protected, not the facts. And this is something that I think non-lawyers really struggle with quite a bit. I think that people think by copying their in-house counsel or outside counsel on an email that everything discussed in that email would automatically become privileged. And obviously that is not the case. underlying facts of a situation are always going to be discoverable. It's your legal impressions and conclusions and the guidance that you provide based on those facts that are going to remain protected. So let's talk a little bit more on who is the client. And again, I have to tell you, having been in your shoes before working in-house, it is, and actually having conducted in my work a number of very high-level internal investigations that were very critical to the organizations, it is a really difficult conversation when you're sitting with the CEO or a senior management team member or a board member who has perhaps brought you into an issue as outside counsel or as in-house counsel is seeking your help and support to explain to them that you actually don't represent them, you represent the company. And that is a really critical conversation to have, but I want you to know I understand how difficult that can be. And so what I would tell you is that by educating people early and often as to what your role is when you're acting as counselor, legal counselor to your business clients, internal, and if you're outside counsel, when you're talking to others, really educate people as to what your role is and what the limits of that are, so that they know. It is much easier when you've informed them prior to a very significant crisis that they understand really what the limits are of your ability to personally advise them. And it's really important that you keep those boundaries very clear. It's really important for your client. It's awkward personally, and I've been there, but very, very important. I just note that there can be some significant limitations with joint defense agreements. I know that there is some pretty significant case law out there where you have executives and organizations where initially it looks like the interests will be aligned, and later on it becomes the case that they're not. In the healthcare arena, and I know that some of you participating on the webinar are in the healthcare field, I think that the Department of Justice has made it very clear that they intend now, when they're dealing with parties and negotiating settlements, that it's going to be critically important that individuals be held culpable for their role in noncompliance or activities that the Department of Justice is investigating, and they're no longer going to grant blanket waivers when they settle to individuals. They're going to need to hold somebody responsible, and that's going to make this all the more important for you to make sure that key management employees as well as non-management employees understand what your role and purpose is. This leads us to Upjohn, and for those of you who have not heard about this case, obviously it's 1981, it's a Supreme Court case, but this case really underscored the fact that a corporation does have the benefit of attorney-client privilege. It also explains how important it is that in-house counsel make it very clear to the client when a communication is going to be privileged as to the corporation. And what has come out of this case, this involved actually the investigation of foreign offices after there were allegations of bribes, and in-house counsel conducted a number of interviews with key management employees as well as non-management employees, and the IRS attempted to obtain copies of those investigation documents. And in this case, the holding was that the privilege would apply to that communication between in-house counsel and employees relating to the investigation, so long as the matter was within the scope of the employee's duties and that the employee themselves were sufficiently aware that they were being questioned in order to provide the corporation with advice. The real issue in Upjohn is that if you fail to make clear who your client is, you may be left with a situation where you have an employee who believes that you represented them and that therefore their statements to you are privileged. That's going to be a big problem for your corporate client when those statements, maybe they want to waive the privilege or they don't want the individual employee to waive the privilege. And so it's critical that when you're interviewing people in the context of an internal investigation, that you're being very clear with the folks that you interview as to who the client is. And it really is something, it's almost like a Miranda warning. And the American Bar Association, in their white collar defense toolkit or whatnot, I don't know the exact name of it, but they provided some scripts that are available. The ACC has also provided a number of tools, but essentially the communication that needs to be had is that you are a lawyer for the corporation and that you do not represent the individual personally. You have to tell them you're conducting the interview to gather information to provide corporation, and that the communications between you and the privileged as to the corporation and can add its own rights. And that the employee will not have, which obviously if employees may be adverse to their own daunting understanding, the consider when you do this is you've communicated this, either documented by the employee of the investigation and the matter statement that they'll have to judge based. I think that the individual discuss the matter based on knowing this in your notes if you don't hang. Now, when would you want to do that? Ask a lot when I'm talking to people, and essentially, I think what you should consider matter. This, as I mentioned, is going to be judged in hindsight. For you who have day-to-day please know at the start of an and be herring that isn't going to be difficult to in advance is going to turn significant for your organization. So that's so important. It's very senior. If the matter directly involves something else, given your warning lights that you, John, warning to the end times at the start, maybe at the box, but I think it's something you should. I think it's something that you should be thinking your team about. And it isn't something where they are the focus. So I think we've covered most of this. Basically, when you're conducting interviews, you need to be really clear. I mentioned you might want to provide a copy of this to the employee. A little bit on who the client is at the moment, but we also want to are going to be protected. And I mentioned it's really where the rubber hits the road. It is very aware of the fact that courts are struggling on the issue of whether the case in most jurisdictions and in fact of a communication has to obtain if the communication is initially provide if communication is initiated legal advice. And so I think a really good idea team that when they want to seek that they either the ray line of the email communicating to you, this is particularly true if they're communicating, but they need to say attorney-client privilege or in the body of the email, or say, I'm writing to you your advice on something. I know overly formalistic, but it's really good to train your team when something really is going to happen, that you set up the communication appropriately. And even if it seems unnecessary, know when it's going to really come to your advantage later. Privilege will always be cared on a case basis, and if you have multiple documents to a single email about the Halifax case, you will in painstaking detail go through each and every piece of the communication, determine whether or not and document protect. I think that business people, again, often mistake believing that because they communicate something or copy the attorney on an email or keep in the loop of a memorandum, that will miss the information discussed in there, privileged, and it's not this if you have not set up correctly. I'd say this is a time where, in terms of really important internal investigations, would counsel you to seriously consider working with outside counsel, because I will say that courts are generally bring a more critical eye to communications between in-house counsel and executives, knowing that lawyers in today's participate in a lot of business activities that are unrelated to the furnishing of legal advice. So it's important to be strategic in how you assert the privilege. I will say I've seen cases where I think one of the takeaways is that the over-application of privilege has really led to a much maybe greater level of scrutiny by the reviewing judge than otherwise would have been if they really were thoughtful about what they sought to protect. I included this in Ray Vayak's case just because it really underscores that the primary purpose test is alive and well. In Ray Vayak's was a product liability case, and in this there were apparently over 2 million documents that were part of discovery, and Merck had asserted privilege with respect to 30,000 of those documents. And what was really interesting, and we can all kind of like scoff at it now, but what they said was our business is so extensively regulated in the pharmaceutical industry that virtually every communication with counsel and various departments is a legal communication for the purpose of seeking legal advice. It's just so entwined into what our business is. We are so heavily regulated that any communication involving our attorney should be privileged. And the court basically said, we are not buying that. And so they went through in, again, excruciating detail to explain where there was communications related to, for example, marketing materials and such. They really looked to see whether or not they felt the primary purpose of that particular communication was for the individual to obtain legal advice, and that it's necessary for the purpose of the communication to be primarily for legal advice in order for it to be protected. And I think that one of the things that was underscored in that case was that the court was really, really concerned that Merck and maybe the industry in general was making an attempt to immunize their internal communications by involving legal counsel, and it was a little too cute. So I think that the lesson here is to really think about your role with your company and figure out ways that you can define when you are a participant in business strategy. And I think lawyers have a lot to add to that aspect of the business, but to make sure that you separate out when you're really advising your client. Let's talk a little bit about the work product doctrine. This is a more narrow doctrine, but it's a very important one. It basically protects the documents, the impressions, the legal theories and strategies of the lawyer. And again, this is actually not as old as the attorney-client privilege, which protects confidential communication, some of which may be in writing. This is a protection for materials that are prepared in anticipation of litigation, is what you'll see. And obviously, for those of us living in this day and age, know that whether or not litigation is absolutely going to happen or not is often not known at the time at which you're being asked to provide advice to your client. Having worked in the healthcare field, I think there is any number of risk management issues that come up on a daily basis that may or may not ever result in actual litigation, and therefore it's really important that when you're dealing with the work product doctrine that you understand what it is that you're trying to protect. Like I said, it's going to be documents that are prepared in anticipation of litigation. So if a document exists before you were ever involved, materials that were prepared prior to the matter at stake aren't going to be able to be protected by the work product doctrine if you did not create them for purposes of preparing for or in anticipation of legal action. Now, I will tell you that courts in different states and jurisdictions, and I practice in Illinois, Wisconsin, and Michigan, the issue of whether or not the threat of litigation really is impending is something that also will be viewed in hindsight, and it's hard to know at the time at which you are trying to protect a document that you're creating. I think particularly important for work product doctrine is whether or not the work product of folks to whom you have delegated a portion of your investigation are going to be protected, and that's where we've seen a lot of recent activity. So if, as part of your legal team, you have paralegals or you have members of the compliance team or internal audit team that are going to be assisting you in gathering facts and formulating your legal strategy, it's really important that you educate them as to the importance of segregating that work product, labeling it as such, and educating them as to why they are preparing what they're doing and have that mindset when they're preparing those documents. Wisconsin, which is the majority approach, follows the because of test, meaning that the document was created because of the threat of litigation, and really the courts will delve into figuring out what the motivating factor was, I think, in most cases, even with the because of test. Again, really hard to deal with dual purpose documents, and it's something that you really need to be thinking about. There's a split in the federal circuits when you're analyzing these dual purpose documents, and while I think the work product document may protect some documents, others that otherwise would have been protected may not if you don't follow the proper steps. So let's talk a little bit about how this applies to the in-house counsel role. I think I will not spend too much time on this, but I do think with the increasing complexity and number of regulations that companies have to deal with today, corporate compliance is something that all companies need to be thinking about, and I think it's almost malpractice not to help your client take advantage of the benefit of having a compliance plan in place, regardless of your industry, given where the federal government is at right now in terms of the enforcement environment. And I think that that has been juxtaposed with a shift from the traditional lawyer role of legal counsel to lawyers being really integrally involved in the conduct of the business and formulating marketing campaigns and the strategy of the business and acquisition decisions. And this mixing of business and legal and compliance purposes has really complicated things for lawyers. I think it's also worthwhile noting that many lawyers now participate in a lot of governance functions, including they may sit on the board. I would counsel you to look carefully at the ethics rules regarding that, because you really may create a conflict for yourself depending on the nature of your role with the board. Outside the scope of our discussion today, but particularly relevant for the privilege, because obviously it will be more difficult for you to assert the privilege if you were instrumentally involved in formulating the decision or making the decision that you're now asked to provide legal advice about. I just wanted to identify some of the hats legal counsel wears. I think that the other thing that I've seen that is interesting, and it's here to stay, but general counsels now often have a non-legal title. And I think that it's important for you to consider the significance of your actual job description, if you even have one. I know a lot of general counsel don't, but also your title and how that connotes whether or not you really are an advisor to your company or whether or not you're really an active participant in the business operations, and what implication that has for your ability to afford your client privilege when you're providing legal advice to them. Depending on how intertwined you are with the business operations, you may want to consider real strategic use of outside counsel when a matter comes up that involves internal investigation, just to make sure that you are affording your client every opportunity to protect their communications related to legal advice. So this is actually a quote from Vioxx, and I had previously spoke about that. I think that the multiple roles of lawyers in companies really underscores the inherent tensions that are created when you're trying to figure out who the client is. Obviously, if you're you're a senior vice president or an executive vice president and you're sitting in on all of the key senior leader meetings and making decisions with the board, that's going to really make it a little more difficult for you to identify your role as a senior leader from the role as counselor to the corporation. Because again, the more you are involved with the business, the less I think it becomes clear that you understand that the client is the corporation, not yourself or your fellow executives. And I think that really is really difficult intersection to navigate. I'd be happy to talk about that when we have questions if you have them. So I wanted to include, obviously, the ethical rules. You are getting ethics credit for this presentation. And I think that it's, again, important to understand that your ethics rules indicate that you represent the organization. Obviously, it acts through its authorized constituents, which will be your executive team, your board, your directors, your senior leadership. However, I think that it's important to note that those individuals are not your client as individuals. When you are dealing with organizations, the ethics rules require that you explain the identity of the client. And so you're almost required by the ethics laws to give that Upjohn warning to people when you're conducting investigations or providing advice. And I just wanted to reiterate the fact that this is a critical part of your duty as a lawyer to make sure that your constituents understand who you actually represent and what the implications of that are. Point here, I think that you can represent, have dual representation. However, I think that this is where that joint defense issue comes into play. And there have been some really significant cases. There was a case, the Ruby case, I'm probably saying it wrong, it's a California decision that basically resulted in some very negative implications for the law firm who represented a CFO and the organization, and then of course their interests later divided. It was a civil case, and I think the importance of that Ruley case, and we're going to talk in a minute, the Wells Fargo case, is just that it is very difficult, I think, in today's day and age to represent both an organization and the directors, officers, and other employees and still uphold your ethical obligations to each of those clients, given the potential for conflicts. I think that the other thing I wanted to note here, this is a model rule, so this is not the Wisconsin rules, but I wanted to note that it's really critical you understand that ultimately the corporation acts through its board of directors, its board of managers, the ultimate governing body. And so when you're providing legal advice, it's critical, I think, that you consider whether or not it's appropriate that that be filtered by senior executives. At some point, you do need to advise the ultimate decision-making authority, and that would be the board of directors. The other issue I wanted to raise here is that it is really difficult if you serve on the board of directors to separate out the potential for conflicts in advance. And I would caution you to carefully consider whether or not you actually have that position if you were going to be general counsel to a company. So I just wanted to mention a couple of these recent cases because I think they underscore the importance of really pre-planning for a privilege. One of these is a healthcare case that people in the healthcare industry have followed for a number of reasons, the Halifax Hospital Medical Center case. And what was going on there is that their compliance officer became a relator and brought to the attention of the government certain false claims allegations that or false claims violations she alleged had occurred. This is now finally settled out. But what became the subject of discovery were all these emails to and from in-house counsel and the corporate compliance officer, where there was business and legal advice being sought in relation to various physician contracts. And I think that, again, it underscores the fact that if you want to really protect something, it's critical that you have the, I don't really want to call it the magic language, because I don't think that would protect something that really was a business communication. But it's really important that the email itself, if you're going to be communicating by email, that you clearly identify and delineate and segregate out emails and communications that are for purposes of ongoing business day-to-day operations and for legal advice. And one of the things that came out of this particular decision was that there's a lot of focus on emails, obviously, and we could probably spend a whole day on the merits of communicating by email in this day and age. But what I will tell you is that the magistrate in this case really spent a lot of time dissecting who was CC'd on the email and who the email was to. And basically, I would say the recommendation that comes out of this case is when you send an email to a client or they're sending it to you, it's important that there not be lawyer and senior executive member or lawyer and business person in the to line. The communication should be to the attorney and to the individual seeking the advice. And I know that sounds crazy, but they basically said that any time you CC'd a business person or send it to a business person and the attorney, it was not primarily for purposes of seeking legal advice, which is crazy. But in Ray, Kellogg, Brown, and Root, I don't know how many of you have heard about this case. This actually came out of the Deepwater Horizon incident, the Gulf of Mexico oil spill. And what was really interesting in this case is, and there were two separate really important decisions that the DC Circuit Court made related to the materials that were sought as part of discovery. But the most recent of which is just to make it very clear that summary reports that are prepared by non-attorneys participating in a compliance internal investigation can remain subject to the privilege so long as the purpose really is to seek legal advice. And I think that, again, a lot of focus in this particular case about whether or not the documents prepared by non-attorneys could be protected, and I think that this decision stands for the proposition that absolutely they can, but it's going to be qualified, and you need to be very careful that it's been properly set up. Wells Fargo Bank, that's a very recent decision, that's September 22nd, and I raised that for you only because it was a civil case, but basically an employee was not able to assert the advice of counsel defense because Wells Fargo refused to waive the privilege related to some of the internal communications between legal counsel and the employees. So, you know, obviously I don't know all the circumstances of that, you know, the backstory of that particular case, but in that case, the employee wanted the court to apply a balancing test and really wanted to access the information, and the court said absolutely not. The corporation is the client here, and it's up to the corporation whether or not they want to waive the privilege, no matter how important that information is to you to assert your defense. Now, this was civil action. I think that it would have perhaps been a different outcome if this had been criminal, but I think it's worth noting that really important, I think, that your employees understand, especially if they're in a situation where they may have personal liability on the basis of your advice, that you think through how you involve counsel and how you notify them of what their limitations are in terms of the attorney-client privilege. So let's talk a little bit about some tips for preserving privilege, because that's really what I want to leave you with. And I say have a plan. I've talked a little bit about that. What might you put together? And I think, first of all, I think that it's really important that you define your role within the organization and that that is documented somehow. I don't know if it's a job description. I don't know if it's sort of a self-serving memorandum that is communicated to the board and senior management, but I think it's really important to define what your role is going to be and think through some parameters of when you're going to involve outside counsel and maybe plan in advance. I can't tell you enough how stressful it is dealing with this in the heat of the moment of a really significant crisis that's facing the organization. That pressure that it puts on all the constituents is so intense. And as in-house counsel, I think you are very well served if you've prepared for it, because then it doesn't feel like an attack when you say, look, I don't represent you, Joe, CEO, we've been buddies for years. I represent the corporation. So I think the other thing that I didn't spend a lot of time talking about, but I think having some pre-planning done with respect to when you're going to secure separate counsel for executives, and just giving that a little bit of thought in advance is worthwhile. Based on your industry, what kinds of investigations or alleged misconduct would be so significant that you would want to explore obtaining separate counsel for decision makers? And obviously the facts and circumstances of every case is going to ultimately tip the scales one way or another, but I think it's helpful to consider these outside the context of the heat of the moment and just have some planning going on. I think that it's really important you train your management team. Again, this isn't intuitive. I think that they think that you represent them, and I think most CEOs see themselves almost indivisible from the company, depending on whether it's a closely held corporation or how big and sophisticated the organization is. There may be a sense that there really is no difference, and I think it's important that you explain to your clients what those differences are and what the significance of that is in terms of their ability to protect their communications with you. I think that when you're doing internal investigations, you would be well served to have a ready-to-go memo that you could use to basically lay out and document that you are initiating an internal investigation. And that memorandum will explain that you are directing the investigation. And typically what I do is I have attachments to the memo where I have a list of all the people who are going to be involved in the investigation, which is supplemented as new persons are added. I think that it's really helpful to have people who are going to be part of the control group understand that they may not communicate with anyone about your conversations with them outside of the meetings. So for example, if you have a senior leadership team meeting and you're providing advice, you guys are in the middle of a really important investigation, them going back to their office and sending emails back and forth to each other about their personal impressions and other facts they may or may not have uncovered or theories they have, not going to be helpful and likely would not be part of the privilege depending on how you've set that up. So it's really going to be the hub and the spoke kind of an approach where everything is going through counsel. Now, having said that, one of the things as outside counsel I know is very frustrating for in-house counsel is, when you are using outside counsel to conduct an investigation, you got to be judicious of the time that your outside counsel is spending on just simple fact gathering and document gathering. And I think a lot of people, depending again on the importance of the matter, but I am involved in audits all of the time for clients, and I typically do a really good job in my investigation memo of indicating who are going to be fact gatherers for me, so that I can have claims departments and accounting departments and executives pull together information and maybe even have meetings about the status of the information they're pulling together without vitiating the privilege. And so I think if you document that in a plan, much more likely that their activities and the documents they prepare are going to be privileged. I think that teaching people about the use of email and the importance of limiting distribution of your legal advice is really key. When we started, I mentioned to you, I can't tell you how many times I've had clients use my email to them and forward it to the other side. See, my lawyer says that, you're absolutely wrong, and that's, not sound advice, or your lawyer's wrong, or, don't do that, and explain to them why not to do that. But I feel all of us have been used in the past either as the shield or the sword at one time or another. And I think that it's important that your clients know that if they do that, here are the implications of that decision. And oftentimes it isn't the best way to go about it. I also tell my clients, look, if you want me to help you draft a communication that you could send, then please let me know and I'll help you craft that communication. But that's going to be separate from the email where I provide you my unvarnished legal advice. The other thing I do that is my, it doesn't always work, but if I have something I'm communicating to my executives that in the middle of a negotiation that I really don't want them to communicate, I put do not forward to anyone, on the email in the subject line. And I will tell you, if it's not overused, it does get people to pause, especially if you do all caps. Right? My husband is not an attorney, and I guess, I supposedly all caps is yelling, but for me it's when you're saying something really important. But I think it's really important that if you prep people for that email, that's the all caps, do not distribute, forward, print copies, whatever you want to put on there, they will know that you're not yelling at them, you're trying to help them. It's the Jerry Maguire help me help you conversation. Additional privilege best practices. We've been through being clear who the client is. Consider in your toolkit for internal investigations whether you have a little document written up that has that Upjohn warning in it. And I'd be happy if you want to give me your business card or email us after to send you that language. But it really, there's no magic to it. But having that ready to go for that moment when you really need it, it's simple, you've got it, they can sign it, or at least you can memorialize that you've advised someone about that. Other important part of your investigation plan is what procedures you might institute for email communications during an investigation. And I talked a little bit about that, but what I didn't say is maybe you have a procedure that you lay out, like all emails will contain this in the subject matter. You will, only include the people that are on the investigation memo, just like a 4 or 5 point instructions to people who are going to be involved in an investigation really can save you a lot of heartache later. And then even if you don't do all this and you don't have a memo because that's just too much or it's overkill, make sure as counsel that you're documenting in your written notes contemporaneously that you're involving people in an investigation, just so that you have that later on. Or if you provide the Upjohn warning to someone and you've counseled them, make a note for yourself, because that really is important for your client. I think that it's really hard to keep everything completely separate, but if there are really important pieces, documentation of your legal advice, really think about how it can be kept separate from documents and materials you prepared in the ordinary course of business. With e-discovery nowadays, it is so difficult later on to separate everything out, much easier in advance. To have separate, inboxes or however you want to do it, but important that you advise your clients of the same. Now, good luck with that, and if you figure out a good strategy, I want you to call me, because I think that's really hard in this day and age with the volume of emails people get, to tell an executive, no, emails I send you that are for legal advice, please keep it in a separate file in a folder. I mean, they're going to look at you like, yeah, right. but when it matters, it really matters. So maybe at least educating them when you are doing an investigation of the importance of doing that, it would help. I'm trying to think if there's any other good advice I have for you. We are at, 10 minutes. So I've been talking to you now for about 50 minutes. So why don't we open it up for questions? And I hope you guys have some. Any questions? We have a couple that we got by email. So one question that we received was, my general counsel and CEO want to be copied on all emails related to internal investigations. Will those emails be protected by the attorney-client privilege? This is actually not something that's very uncommon. And when I've worked in-house, particularly where there is an important matter at stake, I think that the CEO does want to be kept in the loop on things. And the answer to that is, as long as the email is for the investigation and it's clearly for purposes of gathering information to provide the client with legal advice, I think the email will be subject to attorney-client privilege, but I think it would be important that emails are not being sent to the CEO and general counsel. If the general counsel wants to copy the CEO when communicating legal advice, I guess I would make sure that the inclusion of the CEO on that email is appropriate and necessary for the representation. And if you explain to your CEO why you're handling the matter in that way, I think that, again, that's where the planning and the forewarning goes a long way to make sure that you can make your CEO feel comfortable that they will be kept apprised of what's going on. Another question, many routine audits occur in day-to-day business. What types of investigations should be conducted under the privilege? That is a tough question, but a good one. I think that, again, that's going to be a circumstance where perhaps you have multiple factors are going to come into play, but perhaps you have sort of in your own mind or memorialized a procedure that would be followed if something involves a significant material dollar amount. If the penalties for the conduct being investigation are criminal, or the organization could incur legal action or significant fines or penalties, those are things that I really think you want to make sure are subject to privilege. If someone just wants to do a simple review of factually, how many claims have we had, maybe a claims history review for purposes of reporting to the board, how your risk management practices are going. I mean, I think that there are fact-gathering exercises and reviews and audits that aren't necessarily for the purpose of exploring your exposure, but maybe to look at a past history and whether your compliance programs are effective. And so I think, how's that for a nice non-answer? But I do think that routine audits don't all have to be conducted by privilege, and I do think that if you try to use the privilege too broadly, that can backfire on you as well, because if you show a lack of understanding, I think your documents are going to be much more closely scrutinized come discovery time if you are ever faced with a significant discovery process where you're trying to protect documents. How do you invoke the privilege for an internal investigation? That would be done, I think best practice would be by the memorandum I discussed, where you would have you could have a form ready to go where you fill in the specifics of that particular situation and identify the people that are going to be involved. And that's not that hard to do. So I would suggest that if you want to invoke the privilege, that you do so upfront by sending documentation to the team of people that are going to be involved and explaining to them the rules of the road. And would not hurt to make sure you're clear in that communication that you're advising the corporation and that your advice is for purposes of advising the corporation. But obviously the formality of that memo will depend on the particular circumstance. Any other questions? Yes?
You said in dual purpose document setting, where's the 7th Circuit?
That's a great question. Most of the case law has come out of the DC Circuit recently and the Southern District of New York and Florida. Terrific question, and I actually don't know of a recent privilege case in the Seventh Circuit. But what I would tell you is that I think that the case law coming out of the Enrique Kellogg Brown, the magistrate's opinions and related litigation are really instructive in terms of how they will view dual purpose documents. And I'd be happy, if you want to give me your card, I'd be happy to share with you some of those, because I mean that it doesn't take hours and hours to read them, but if you look at the thought process that they go through, it really does make you pause and think about how you write your legal advice to clients or provide your legal advice to clients. So I think it's a worthwhile 10-minute read while you're having a cup of coffee sometime. So if you want to give me your card, I'd be happy to send that to you. Yeah. Yeah.
For dual purpose documents in the context where you have, we need to learn about a product liability. I work for a manufacturer. If we have something in the field that allegedly malfunctions, we oftentimes send that engineer out, they look at it and write up a report. Legal department asks them to do that. As long as they say, as long as they don't say maybe, yeah, we do this for some purpose other than pending litigation, will the court take that at face value, or will it, I mean, as long as I can train them to say, I'm doing this because the legal department asked me to and we think we might get sued, is that going to be enough to keep it out of the whole dual purpose, or will the court say, well, aren't you also really doing this because you want to know if there's a problem with the product?
I think that you will find the KBR opinion riveting, given what you've just explained to me. And what I will tell you is that I think that it goes a long way to make it very clear that when that happens, there is the anticipation of litigation, and you're preparing those documents because of that threat of litigation, and papering that appropriately to show that would be helpful. However, having said that, what was that issue in the first KBR case, which was not the one I was dealing with there, but whether or not they had a legal obligation under federal law to conduct an investigation into the failure of their oil drilling containment equipment. And so what was argued was that because the purpose was for complying with that regulation, that it should not be subject to privilege because it wasn't really prepared in anticipation of a legal threat, legal litigation, or some other enforcement action. And so I don't know whether or not in the situation you described you have an independent legal duty to prepare that type of report. I can tell you an analogous situation is the typical incident report in a hospital. And it's pretty much well documented that your incident report, that you prepare, or a safety report outside the context of a peer review process, which is probably not something you have to deal with, but your routine business record. So take the slip and fall. Patient slips and falls. The nurse writes a report on that, and it gets sent to whomever to be reviewed in the process of normal quality control operations. That I see as being different than the attorney saying, look, we really need to know whether or not our procedures were complied with in this particular incident. And who was involved, and interview witnesses and other people so that we can really understand what our legal position is with respect to this particular matter. So I think part of it would be exploring whether or not you're required to prepare that report, and then making it clear that the one you're asking for is so that you can advise your company. And maybe keep documentation of the required incident report of that equipment failure separate from the report the engineer prepares for your purposes. That would be great. The other thing that I will say is that, and this seems like a really trivial thing, but it's really important that every page of a document have attorney-client privilege and work product written on it. So it says subject to attorney-client privilege and work product privilege. And you just put it in the header on every single page. When all these pages of documents are looked through later on, the fact that it's on the first page, it can then be taken by someone. People might take a particular, if you take an Excel spreadsheet that has multiple, tables in it, people can take out one piece and it won't have that heading, and so materials get moved around. So make it something where they're required to put that heading on every single page of the document. That's going to be huge later on, just to make sure that you are really clear and consistent that this document is intended to be privileged. So especially if it gets separated out or different aspects of it get used for different purposes. Anything else? Thank you very much for your time.